Welcome again to our Juris Doctor Masterclass, The Good Lawyer, Exploring Legal Duty and Ethics. I am Dr. Andrew Burke. I'm the director of Macquarie's Juris Doctor course. So I'm the academic at the law school who's responsible for the Juris Doctor. And I'm also a lecturer at the law school, and I teach a couple of units in the Juris Doctor. I'm a criminal lawyer, so I teach a criminal law unit and also a criminal procedure unit. So if you do the JD, you'll certainly be seeing me on more than one occasion. This evening, we've got a really interesting masterclass planned, presented by my colleague, Dr. Amanda Head. Amanda teaches legal ethics, which is one of the early units you do, all about the ethics of being a lawyer, in addition to remedies and research methodologies for our school. Right? So she's a really experienced, capable teacher teaching in a number of areas. Amanda is, like me, a graduate of Macquarie Law School. Right? We're both products of this school. And her diverse experience ranges from being a practicing solicitor in family law, a certified practicing accountant as well, and her research has been published in the areas of both family law and succession law. So, over to you, Amanda.
Thanks, Andrew. Welcome, everybody. So today we're going to be thinking about the place that lawyers have in the legal profession and the place that they have in society. And we're going to have a look at the fine line that lawyers have to sometimes walk. And I'm just going to start by reading this quote. So solicitors, like all members of the community, are subject to the law, statute, and the common law. However, the legal profession is in a different position in a twofold way. A breach of the law might bring professional as well as legal sanctions, but also members of the legal profession may be excused from complying with the law, as ordinary members of the community must, where that is for the purpose, for the proper protection of the client. So, for example, where legal professional privilege applies. And this often raises vexed issues and requires lawyers to walk a fine line. And it's interesting, in particular with respect to criminal defence lawyers, where they're acting for a client, a lawyer is necessarily associated with their client and can appear, at least to some extent, as if they're acting in combination with their client. In combination is one thing, improper combination with their client, so where it might amount to a conspiracy to commit a crime, for example, is another thing. So we're going to look at a number of different ethical dilemmas. They're all based on real cases. Before we delve into that though, just to sort of set you up, I want to run through some of the main duties that we're going to be touching on and that lawyers owe. So the first one that I want to talk about is the duty to the administration of justice. And this is a paramount duty that lawyers owe to the administration of justice and to the court. And I hope this diagram gives you an indication of what we mean by the duty to the administration of justice. An important thing to note is that our duty to the administration of justice in the court is not a duty to justice or to do justice. It is indeed the justice system's duty to do justice, and hopefully it does it well. When we're thinking about our duty to the administration of justice, we need to really think about the lawyer's role in that greater justice system, and that our obligations and our duties fit within that bigger system, as you can see here. And so the idea is, and this is sort of my visual representation, is that a legal issue goes in one end and it goes through the cogs of the justice system. Being involved with lawyers is one thing. You might go to court and out pops justice at the other end. Now, that is idealistic, obviously. Our justice system has issues, as most justice systems do. Our adversarial justice system in particular has access to justice issues. It's very expensive and quite time consuming, and this is really quite problematic. But for the purposes of understanding our duty to the administration of justice, I hope that you see as part of this representation that lawyers fit within the much bigger system. It's also important to think when we're thinking about our duty to the administration of justice is the other duties, some of the other main duties that might fall under that. So we have a duty of confidentiality, and this essentially is within the lawyer-client relationship, and it basically means that a lawyer has an obligation to keep their client's secrets. Of course, this also relates to legal professional privilege. Lawyers also have a duty to act in their client's best interests. They have a duty to of loyalty to their clients, which is sometimes called a fiduciary duty. You may have heard of that. And related to this is a lawyer's duty to avoid a conflict of interest with their, they can't have a conflict with their own interests. They can't have a conflict of interest with another client, either a current client or a former client. And of course, lawyers are also obliged to uphold the law and obey the law. So on to our first dilemma, our ethical dilemma, which I've called the morning raid. So you were sitting quietly in a bar one evening, enjoying a drink with your friends, when you recognise off-duty police sitting nearby. You can overhear the conversation. And what you overhear is the police planning a morning raid on one of your clients in the next morning on one of your clients. Your client is a local bikie club who you have represented in court, and they're a current client of yours. So what do you do? And we have a poll, which I will just launch for you to answer. So the first option is I do nothing. I continue to enjoy my evening because I'm not on the clock. The next option is I do nothing because that would be colluding with my client. The third option is nothing because if the raid is successful, it will mean more work for me. And the last one is pick up the phone and warn your client. So pick which option you think you would do in this circumstance. So the correct response is either really A or D. The least ethical response is C, because you really shouldn't be motivated by your client's misfortune with respect to your own generating your own revenue. But you may be interested to know that this sort of thing is actually not colluding or it's not acting in improper combination with your client. And indeed, in the actual case that this particular scenario is based on, the lawyer not only rang his client, he also said to his client, you know, get rid of the drug utensils and the cash and everything. He was charged with perverting the course of justice. He was also charged with breaching his duty to the administration of justice. And of course, if you are conspiring with your client with respect to drugs, you might be guilty of Section 26 of the Drug Misuse and Trafficking Act. And there's also, conspiracy is also a crime under that federal legislation. But ultimately, our lawyer was found not guilty of it all. And there are a number of reasons why this is. So firstly, police inquiries, generally speaking, are not part of the course of justice. So we can think about this in a separation of powers term. So justice, the course of justice is part of the judiciary. We've also got the legislature and the executive. And the police, general police inquiries are actually part of the executive. Unless there is a connection to a court case, they're actually part of the executive. So their powers generally are not part of the course of justice. So that was one reason. But the other reason was understanding, if you understand the lawyer's role within the criminal justice system, in particular, and a defence lawyer's role within the justice system and our adversarial system. And at the end of the day, there is no duty on a lawyer, and there shouldn't be a duty on a lawyer to assist the police. it is within the realms of the law legally to actually frustrate police inquiries. So, for example, a right to silence is frustrating police inquiries, or resisting a search if it's not supported by a valid search warrant is frustrating police inquiries. And these are all things that you're allowed to do within the law. Although the court said, although the lawyer in our case may have suspected there was drug utensils or cash on the premises, there was no allegation that he knew. It would make a difference, I think, if he did know. That gets a lot closer to conspiracy. But in this case, they said there was no allegation that he did know. Also, there was no allegation that he obtained the information about the raid illegally. And so they said, the court said he hasn't actually done anything wrong at all, and he is well within his rights. And when you understand the defence lawyer's role within the justice system, that sort of makes a little that adversarial role, with the lawyer needing necessarily to be partisan with their client's interests. So the next one's the confession of the guilty client. So you are a lawyer who has recently moved out of corporate law into criminal defence law, and one of your first cases is a man accused of murdering a father and daughter. Your client and the father who was murdered are were well-known members of a criminal cartel, rival criminal cartels, and the daughter walked in on the father being executed and was executed as well. In one of your meetings with your client confessed their guilt. They said, yes, I did it. And they told you information that would allow, if the prosecutors knew, it would allow them to obtain a conviction. You're sure that your client did it. And you're now distraught because they want to plead not guilty and go to trial. But if they get off, they could well do it again. What do you do? And I'll just launch our next poll. So the first option is pick up the phone and give the evidence to the DPP. After all, isn't that assisting the justice system, a system which you have sworn to protect? The second option, withdraw from the case and decide that criminal law is just not for you. Third, withdraw from the case as you now know they are guilty and therefore can't represent them anymore. And the last option is not say anything to anyone and continue to represent your client. Let's look at C first, which is withdrawing from the case as you now know they're guilty and can no longer represent them. Now, firstly, Section 316 of the Crimes Act basically says if you're concealing a serious indictable offence, then you could be liable to be imprisoned for 5 years. And you would think that lawyers who know this sort of information, murder is obviously a serious indictable offence, about a client, it would fall under this section, and therefore surely a lawyer could be charged with this. But in actual fact, there is an exception within that section that says if you obtain that information through your profession, and lawyer being a profession, then you're exempt from being charged under that section. And it makes sense because one of your obligations is to keep your client's secrets. But also our solicitors and barristers rule actually allow for this exact scenario, and they tell us what to do. So when you know your client is guilty, but they want to plead not guilty, you are actually allowed to continue to act for them, provided they agree to what is called a frozen defence. So this means that you should challenge the prosecution, make sure that they meet their burden, challenge the evidence, make sure that they prove their case beyond a reasonable doubt. But you cannot allow your client to give evidence denying their guilt. And you can't put forward a case that your client didn't do it because somebody else did it, because you know that not to be true. So although you can put in a plea of not guilty, even though you know your client is guilty, you can't do anything else around that that might be misleading the court. and your client has to agree to that. If they don't agree to that, then you have to withdraw. Now, I want to think about A, which was, and I'm just going to take you back to this slide on our duty to the administration of justice. And A was ringing the DPP, so the prosecution, and telling them what you know. Now, this is very problematic and really is the basis of the Lawyer X scandal, which is where I drew this particular hypothetical from. And you may have read about Lawyer X, Nicola Gobbo, as she's now known, we know who she is. You may have read about her in the media, and she continues, and matters that she was involved in continue to be in the media. As I mentioned, the adversarial system works best, our justice system works best when everybody within the system does what they should be doing. Like a well-oiled machine, in theory, is how it's meant to work. What do you think might happen if our little blue cog here, our lawyer clog, moved out and left this system and went off and did its own thing? Well, as you can imagine, the system breaks. And this is what the High Court had to say about it. And this was when they heard her matter about whether actually to disclose her name or just still be known as Lawyer X. This is what they said. Ms. Gobbo's actions in purporting to act for counsel for the convicted persons while covertly informing them against them were fundamental and appalling breaches of her obligations as counsel to her clients and of her duties to the court. As a result, the prosecution of each convicted person was corrupted in a manner which debased fundamental premises of the criminal justice system. So it's very, very strong words from the High Court. It's not just a matter of just telling your secrets to your client's secrets to the police. It's actually really quite fundamental. And this is some of the, just a small bit of the fallout from the Lawyer X whole issue. So firstly, Frank Oman was a convicted murderer. Nicola Gobbo was his barrister. And since this has come out, he appealed and he's now free and his murder conviction was quashed. So basically the justice system has broken. Tony Mockbell, I'm sure anybody who reads the news would have read about Tony Mockbell. He's still in jail on other charges, but he had his conviction for importing drugs quashed. And then there are a number of other people who were convicted criminals who are now out on bail waiting to have their matters heard because the courts have found that there is a real risk that their convictions are unsafe because of the information that was disclosed. So the correct answer for this is B or D. D is correct. As I have said above, you are allowed to continue to defend your guilty client, and even if they plead not guilty, provided you adhere to what is called that frozen defence. And you are allowed to withdraw from the case. However, it is really important to note that this can only be done in certain circumstances. We, as lawyers, we have a duty of representation. It's really interesting. A client can wake up one morning and decide that they don't like you anymore and just go and find someone else. Lawyers don't have that privilege. We have an obligation to continue to represent them. And if you don't like your client anymore, you have to continue to represent them. And you can only withdraw in certain circumstances. The end of the retainer is usually when your representation will end. But also if you have just cause and you give reasonable notice. So there's some fairly strict regulations around the circumstances in which a lawyer is allowed to withdraw. Clients, on the other hand, can just leave. Okay, so moving on to our final scenario. And we're moving out of criminal law here into civil law and out of the court and into negotiation. So for this one, you are an insurance lawyer representing an insurance company. The person insured by your client was driving a car which crashed into another car and injured the driver of that other car. Your client has admitted liability and you're representing them in negotiations with the lawyers of the injured driver regarding the quantum of damages. Now, the injured driver has had a number of medical exemptions, including one by a medical expert that you commissioned. You've just received your report from that medical expert, and it has revealed a potentially life-threatening aneurysm that was very likely caused by the accident. The injured driver's legal team is unaware of this injury because none of the other medical, so it's their client, but none of the other medical experts have picked it up. None of the other doctors that have examined the client on the other side has picked it up. If you disclose this information to the other side, then they could potentially get more settlement. They would ask for more compensation. But it's also life-threatening. So what would you do? And I'll just start the last poll. Okay, so the first option, not say anything, as my duties are to my client and disclosing this is not in my client's best interest. Second option, say something, as the client on the other side should know this given it is life-threatening. And the third option is wait until the settlement is complete and then say something to the client. Okay, I'll just go through. I'm just going to start with what the law says at the moment. So under the rules, the solicitor's rules, which I've got a brief summary up here, and also under general law, generally speaking, in a civil negotiation, there is no obligation, no positive obligation to disclose an adverse fact, which is what this is. Of course, if you decide you want to, at the end of the day, it is confidential. So you would most likely need to get your client's permission to disclose it. Even if the matter is finished and the retainer is over, it is still confidential information because confidentiality is immortal. It goes on forever. Even if your client dies, so this is a corporation, but if your client is a natural person, even if they die, it is still confidential information. And it is not yours to disclose. So if you did decide that you were going to disclose it, it is something that you would need to run by your client. But back onto this general rule that there isn't a positive obligation to disclose adverse facts. And this is facts that we're talking about. There are two main exceptions to this rule. Firstly, you must disclose if the information is needed to avoid a partial truth. And you also must disclose the information if it's necessary to correct a statement that you've made previously, which you now know to be false. But aside from those, an adverse fact, potentially you're allowed to keep secret. So just thinking about this in the context of our negotiation, if you agreed with the other side on a list of injuries, for example, and you excluded this injury, then that would be misleading because that would be the partial truth. But if in the process of the negotiation, there was no mention of injuries at all, if the negotiation was just the lawyers coming in and throwing numbers around, you know, oh, I think 10,000, oh no, I think 20,000, and that sort of negotiation, then this type of medical record is not something that there is a positive obligation to disclose. Of course, any reference to common morality would, I think, potentially encourage a lawyer to find a way to disclose the information. As I said, it is confidential though, so you would want to speak to your client. But ethically, provided what you have disclosed around the report is not misleading, there are no positive obligations to disclose. And the lawyers in this scenario, I'll just give you the background of the actual case that this was based on. This was an American case. They didn't disclose. It was an aneurysm caused by a car accident. And the young man, they didn't disclose it. The young man went to enroll in the army a couple of years later, and the aneurysm was discovered in the medical examination. And he came back to the lawyers and said, oh, there was a mistake. And the lawyers said, no, sorry, we knew, we just didn't tell you. He ended up having an operation to remove it and actually ended up losing his voice. This was reviewed by the court. The decision of the lawyers not to disclose anything was reviewed by the court. And the court said in the process of the negotiation, the lawyers didn't do anything wrong. And I guess we can think about lawyers in this way as more of a traditional type of lawyer. They're often represented in pop culture as what we call this adversarial advocate. So this idea of really being very focused on so duty to the court and administration of justice, but then really being focused on your client's interests and not thinking about the matter any more broadly, is sort of win at all costs type mentality. And the insurance lawyers that I've described here very much fit within that conception. But it's not the only model of lawyering that we have. We have a responsible lawyer. And a responsible lawyer is someone who's an officer of the court and a trustee of the legal system. So when they're advising their clients, they might think more broadly than just the adversarial advocate, which really hones in on the client. They might think more about substantive justice and other people's rights that might be affected by their clients' actions. They are still partisan to their clients' interests, but when advising their client, they do look at the issue more broadly. We also have a moral activist, and they're more in terms of agents of justice through law reform. So a moral activist is someone who might take on a client because that particular issue is something that the lawyer feels passionate about. So it's more about the lawyer's own personal views, more of a moral perspective. And interestingly, the moral activist is actually a lawyer who is actually more likely to bend the rules or even break the rules to achieve that idea of the greater good, depending on what their conception of justice is. And this is one of the criticisms of the moral activist type of lawyer, is that it can be seen to undermine the justice system. And I guess you could say that Lawyer X is a moral activist on steroids, like to the point of breaking, really. And then lastly, we have an ethics of care, which is a different type of lawyering, I guess, and probably more suited to areas like family law, where you think about the legal issue and the potential course of action and how that might, what you're advising your client, how it might affect the community more broadly, and also the relationships between people. And so just to finish off, I am going to just have a little look at just three examples of how lawyers are represented in pop culture. And I must say, this is one of my favorite movies. So Primal Fear, it's in the 90s, where Richard Gere is starring as Martin Vale, and he's the attorney, criminal defense attorney, and Edward Norton is his client. Edward Norton does a sterling job of this role, I've got to say. And he's accused of murder. Now, Martin Vale, Richard Gere, Martin Vale, is a defense attorney, and he is known for acquittals that for high profile clients. He's a little bit of an ambulance chaser. He's sort of, if someone's on the news, then he's in there trying to get that client. And he's well known for getting clients off on technicalities. So very much that adversarial advocate, that traditional lawyer that you will often see in a lot of movies and TV shows. Suits, there'd be no good ethics masterclass without reference to Suits. So here we have Harvey Specter in this series. And if you're familiar with it and have listened to what I've said about adversarial advocates, you might think that he's more of that adversarial advocate. And there's definitely an adversarial advocate in there for sure. He seems to be ready and willing to do whatever it takes to win. But interestingly, with this character, if you look at it a little bit more deeply, he's also a bit of a moral activist, because he really only likes to represent clients that he agrees with their matter. So if he ethically agrees with their matter, then he's going to take them on. So his client selection is a little bit more of a moral activist, where his actual representation is more of that traditional model. And indeed, he's been seen to deceive and bully and defraud others in his hyper-zealous advocacy and in achieving what he thinks is right and winning. And then lastly, we have Harrison Ford in regarding Henry. And Harrison Ford actually plays two lawyers in this, the same person. We have our adversarial advocate, and you can see the picture there with the slicked back hair. And the movie opens with, this movie's actually been panned by the critics a little bit, but I quite like it. The movie begins with him defending a hospital in a malpractice suit with a plaintiff who claims, but is unable to prove, that they warned doctors about a pre-existing condition. And the lawyers representing, so Harrison Ford representing the hospital, should I say Henry Turner, representing the hospital, have evidence that the plaintiff did tell the hospital about this, but they chose not to share it. So very similar to our so our insurance lawyers, they're withholding information. That very traditional conception. And personal morals or any reference to common morality is just not even remotely relevant when considering the client's interests. But the plot twist in this movie is that a couple of days after the trial, Henry is shot, and he survives, but he's in a coma for quite a while. And when he wakes up, he's a different person. As it turns out, he develops a moral compass. And towards the end of the movie, he goes on and visits the plaintiff and gives the plaintiff the evidence that shows that they did warn the hospital. So I guess here we're drawing a little bit more on the responsible lawyer and potentially an ethics of care type approach here. So that's that particular movie. I really recommend. It's one of the things that I do as an ethics teacher. One of the things I do each year is make sure that I'm on top of all the latest movies with respect to lawyers to research for my course.
Thanks, Amanda. Excellent. Really interesting insight into legal ethics. And yes, now's the time for questions. I should say, response to the chat, so I mean, yes, it's definitely unethical to hold yourself out to be a lawyer when you don't actually have a law degree. That's really very black and white. Can't do that. There are questions now. Of course, we're going to have questions about Amanda's presentation or about the Juris Doctor generally. Happy to field questions about either. Again, you can either raise your hand using the raise hand function, or you can put it in the chat if that's easier for you. Question about anything at all. In fact, Macquarie University generally, what it's like to study law, anything you like related to doing a Juris Doctor.
My question is around really honing in on that specialty and then the likelihood that I will end up being able to work in that. Like, do you have advice around how I can go about kind of building on the specific interest that I have? Okay,
so good question. Every law degree in Australia, no matter which uni you go to, has certain required content, which is known as the Priestley 11, right? Certain units. So everyone has to do those subjects. We call subjects a unit. So that's what I mean by unit. So no matter where you go, most of your subjects will be, that required content, which covers all the things you think of: criminal law, ethics, property law, contracts law, all your core sort of legal areas. And then you get to choose electives. Now you get 6 electives in the Juris Doctor, and that's where you more get to pick the ones that you're interested in. And I guess, as you say, specialise. You could do a number of environmental law units or more commercial law type units, and so on. I would say too, look, a lot of students will come into a law degree thinking that they want to be one kind of lawyer and then emerge realising they want to be a different kind. Like, you might find there's a different area to what you know about, or not at all, too, I guess. But look, in terms of then your part of your question about the likelihood of getting work in that area, There's a lot of support at Macquarie in terms of career direction, much of which I have to say is organised by the Law Student Society, MULS, which is amazing. There's a lot of career fair events where legal employers of all different kinds come here or are online explaining how to apply for jobs with them, cadetships, all that sort of stuff, because they want good graduates. So there's a lot of opportunities to get into your area of choice. And also you can use your PACE unit. Every law student has to do PACE. It's a silly name, but it stands for Professional and Community Engagement. It's when you spend a unit in the legal workforce and get credit for that. You can do that in your area of interest to help get that experience as well. I hope that answered your question, Kate. I should say too that when in all our communications with law firms, which we do a lot about what you're looking for in graduates and so on, they're actually not that worried about which electives you've done. They're interested in your marks generally, but your skills and your personality. So they might be a commercial law firm and you might not have done a lot of commercial law electives. They actually don't mind. They back themselves to teach you the skills that you'll need in their firm.
So my other question was, can those electives be taken at a different university?
The answer is, it depends. That's a very legal answer, isn't it? It depends. Some students do. There are some requirements that are a bit too boring to sort of step through now, but they need to meet certain criteria and so on. But yes, it is possible, is a short version. Okay, Danielle.
Hello, thank you. That was really interesting. I'm looking at maybe coming into law as a career change and currently working as in a full-time job. How does the JD sort of support people like who are a bit older wanting to move into, I suppose, this area? Like, are there courses in person in the evenings, etc.? Because to be honest, I'm sure we're all kind of sick of online learning and I'd love to be able to get back into a seminar space in person, but I guess it depends on how practical that is. So yeah, just a question around, I suppose, moving into law from a different career and this, how, you know, feasible is it to do the JD while doing that?
Look, that is the typical profile of our JD students. They're usually people who have obviously done a degree, gone into the workforce, and then are thinking they might like to change or to broaden their skills and their qualifications. So most of our students are working full-time. For that reason, you can either do the classes on campus, but they do tend to be during the day, or the evening classes, which are online and designed for people who are working full-time, but also might not live close to Macquarie, or might live in a different city, for example. And so provide that extra flexibility. We find about 2/3 of our students want to do the online evening classes and about 1/3 want to come on campus during the day. But again, there's a lot of support in terms of helping you to find your start in the legal industry. The thing is, the legal industry wants good graduates, right? It goes both ways. Our graduates want jobs, but they want good graduates to hire. So they come here and sort of, pitch to students, this is why you should come and work for us, and this is the process, and this is how you apply. MULS have organised 20 plus events like that already just so far in 2022, 20 separate events with different legal employers and all different kinds, big commercial firms, legal aid type stuff, non-profit type stuff. So there's a lot of that assistance. But yeah, I mean, that would be the typical profile of our students. We have all sorts of people, police officers, school teachers, people working in all areas of the workforce who are looking for a change. Does that answer your question, Danielle?
Yeah, that does, because I am a school teacher, so that's really encouraging to hear that. And I guess I was just thinking, there's the grad cert in laws that you guys offer, which I was thinking of maybe doing to start off with. Is that can that go as credit towards a JD, or is it a totally different?
No, absolutely, it's credit. It's designed for that. So the 4 units in the graduate cert are 4 units that are compulsory units in the JD. And if you move from the grad cert into the JD, you get full credit for those units. You don't have to do them again.
Oh, cool.
So you've already one full-time semester into the JD. You're a sixth of the way through at that point.
Thank you for clarifying that.
No, good question. Because if you've got that question, probably others do too. So that's useful.
My question is around approach approach to the JD in law, fields of law that aren't quite, that are constantly changing. So for example, AI and ethics in AI and data, I know there's already quite a lot that's happening in Australia, but the AI industry is of particular significance when it comes to things always changing. So obviously there's the time that it takes to go through the study and build the capabilities and build the knowledge, but the industry is also changing at quite a rapid pace. So what would be a good way to approach that sort of balance, to still be on, like, to be up to date with what where you come out the other end of the program?
Yeah, look, great question. And it is a constant challenge in legal education to keep up to date with the technology that's being used. Personally, I'm involved in a research project at the moment about the use of artificial intelligence in policing, predictive policing, they call it, and all the pitfalls and problems associated with that. Look, we have some great units in law and technology, intellectual property, and so on that cover that, and we also try to integrate it into all our units whenever it comes up. For example, I was having a conversation yesterday with one of our torts teachers. Torts is like civil wrongs, like negligence and so on, about bringing into our teaching the use of the AI algorithms now they use for discovery to read documents. So in the discovery process, particularly in commercial litigation, one side might have to turn over thousands of documents, might be millions of writ pages. And in the past, paralegals actually had to read every page of that and make notes. Now they use algorithms, right, to search for what they're looking for. So we're always trying to bring that into our teaching. If it's something you're interested in, obviously your own sort of keeping up to date with all that sort of technology and stuff is going to be important as well. But that said, look, bear in mind too, the vast majority of lawyers practicing today were not educated in that stuff. A lot of them don't know anything about it, but their firms still use the technology. So they find ways, right? Almost no judge understands how AI works, I can tell you, right? They're not educated in that. So you don't necessarily need to be expert, but you need to know the role that it plays within the legal system, and how to ask the right questions about it and so on, if that makes sense. I'm just having a look at the chat as well. So I mean, where there is the ethical line, well, there's a lot of rules for solicitors that you can always check, or you can get confidential advice from the Law Society, the solicitors kind of union, if you wish, if you're really stuck on something. It's the main thing is that you can't always follow your own personal ethics, the professional ethics, the ethics of your profession, rather than what you might think yourself. I'm a criminal lawyer, believe me, I've been there. I'm looking at the question too, are all lectures and tutorials recorded and available? Okay, so all lectures are recorded, right? So even if there's a live lecture in a lecture theatre, which we're back to doing, it's automatically recorded, right? There's a video camera on me and my PowerPoint slides are captured, and you can watch that whenever you want. So you don't have to come to the live lecture. You can watch the recording, or you can watch it after you've been to the live lecture for a recap. So that's how lectures work. Now, tutorials are not recorded. They're more small group discussion. And yes, attendance is not compulsory, but there's usually a mark for your participation, and you can't participate if you're not there. So you can't get any marks for that. So we really want students to come to the tutorials and to engage and speak and discuss. Your verbal expression skills are super important in law and for getting a job, and for doing well once you get a job. So we assess that, right? We have marks for that to develop that skill. And obviously, if you don't come, then you can't do that. Does PACE need to be done the final year, or could be? Yeah, you can do PACE earlier. It doesn't need to be the final year. A lot of students wait to see what sort of law they're kind of most interested in. You know what I mean? Before and when they're closer to graduating, but you don't have to. Going through the chat, what would consider other specialties at Macquarie? The specialties at Macquarie. Look, we've always been strong on environmental law. We have certainly as well quite a number of human rights lawyers, and we're kind of strong in that area. We're increasing our expertise in commercial law with a couple of recent new hires of staff. So in terms of your 6 electives, there's a really strong range of options. I think what we offer in terms of not so much just the course content, but is the flexibility to either be online in the evenings or on campus, and you can mix and match, right? You can do one unit, one subject one way, one subject another. You can change from semester to semester. You might start on campus and then start working full-time or want to go online. So it's very flexible. Question for Deirdre, are there any CSP places? Yes, there certainly are. There's a lot of CSP places. Now it depends upon your marks and your earlier degree. But yes, a lot of our students are on of CSP. Go back up to the chat. So it's hands up. Siobhan, you've got your hand up.
Hi, can you hear and see me?
Yes.
Yep. Hi, so actually my question is just following up on that as Commonwealth supported question. What would be advantageous in your application for securing a Commonwealth supported place? I only actually recently finished my bachelor's, but I did science with honours. So I'm wondering if having honours helps and is an advantage, or if it's mostly done on that GPA or WAM score.
It's mostly done on WAM. It's mostly done on WAM. But then you can look at some kind of flexibility within that. So you said you've just recently done it. If someone, on the other hand, did their degree 15 years ago and has a lot of relevant professional experience, you might take that into account. Sometimes they come to me and, like, for example, someone has a PhD, but their WAM or undergraduate degree was just done. And I'm like, come on, you're kidding me? This person's got a PhD, like, let them in. If your WAM is a little bit below, you can make an argument if you had any extenuating circumstances during your period of study, anything that made it sort of difficult for you, then now you think you're in a position to do better. Or you could argue that, look how my marks increased through my degree as I found my feet as a student, and I really got good at it.
Which definitely happened with me. There was definitely a big improvement between that first and my final years. But yeah.
So yeah, you can certainly make those arguments, and where they're maybe below the WAM but not so far below, they send them to me to have a look at, and I'll take that into account.
Perfect. And just following up on what you were saying with specialties, what I am most interested in is that environmental law. What's your kind of opinions on career pathways with that environmental law? Is there a high demand for environmental lawyers, or not so much at the moment?
So you're saying your other degree is a science degree, yeah?
Yeah, I studied marine biology and environmental science.
Yeah, me
so
too.
I wanted to now go into, I always thought I wanted to understand the physical science and then later on do law to understand how I can implement legislation and policy to kind of affect those positive changes that we're seeing in that science world. So that's definitely where I want to kind of go in, and I know that I'm probably not going to change my mind, but it's definitely good to know how that industry is looking right now.
Look, my other degree was environmental science too.
Oh, amazing.
I can tell you there aren't many of us. I think it's 3 or 4% of lawyers have a science degree. The vast majority of lawyers understand absolutely nothing about science. So it's actually quite a useful niche, right? So in the areas of law where science is important, those lawyers are quite valuable because they have a working understanding. So, for example, planning or environmental matters in the Land and Environment Court can be a really useful niche. It also can be, you're talking about policy and so on, public sector, the government departments that work in environment. The Environment Protection Agency obviously has a large legal section. And when you're dealing with, say, pollution prosecutions, for example, having somebody who understands the science, really useful. So it can potentially be very powerful, very powerful. A cousin of mine recently graduated, is much younger than me, from UNSW, and he's got an honours degree in genetics, and he's now working in the legal patenting of human genes, for example.
Amazing.
So, and there's like 2 lawyers in all of Australia who understand that stuff. Right?
Yeah, well, that's good to know that it is a bit of a niche. And yeah, so that's quite exciting to hear. So see how it goes.
Good.
Thank you.
No worries, Siobhan. All right, Sebastian in the chat, maximum number of years to complete. I'm not sure what the university's rules are about maximum number of years. It's never come up. I imagine maybe after 10 years or something, they might start to like tap you on the shoulder and go, any plans to wrap it up? But I'm sure you wouldn't want to take that long anyway. It's most students, it's very common to be part-time. Majority of JD students are part-time, which case if you're doing 2 units a semester, it would take you 6 years. Not many people would take much longer than that.
Well, the reason why I asked this question, because I'm a practicing physician in Newcastle, and so I'm doing part-time for now, which is great. And so I'm trying to kind of like dip toes in the water in terms of equipping myself with the grad set of laws and see whether or not this is the right pathway to do so, because I'm really want to look into medical legal stuff, health law, policy making down the line. And so I just want to be sure that this is actually the right course to pursue. So, and I have been supported by my sister, who is a practicing lawyer, and she's very happy with it, and she's very supporting. And so I'm going to take one subject per semester for now and see what happens. All
right, well, good. Yes, one subject a semester. And I'm sure with the university, as long as you're making progress, even if it's one subject per semester, the university is happy. It's more the students who go for a period of time without studying anything, I think, that cause concern. Yeah, I imagine that will be fine, and good idea, good dip your toe in the water. We have a wide range of different types of assessment. We have some of your traditional sort of research, traditional essays, if you like, requiring legal research, and they're just submitted online, right, through a system that verifies academic integrity and so on, that it's not, that it's not too similar to anything else. But not just the essays. When I did my law degree here, it was just essays. We're trying to do more of what we call authentic assessment, which is assessment tasks that mimic the sorts of things that lawyers actually do. So advices to clients, that sort of thing. In one of my units in criminal procedure, we do a mock client interview where you're a lawyer and you have to interview with me and I play the client, which is kind of fun. We also have things, we have online quizzes, and also things like take-home exams. So a take-home exam is really just like a normal exam with a number of different questions to address, but it's released online for, say, 2 hours or 4 hours or 6 hours, and you have to submit it online within that time. It's obviously open book, right? But all our assessments are open book. We moved away from closed book exams a long time ago because closed book exams are of no use. Lawyers don't have to memorize anything. We used to. When I graduated in the 90s, you had to memorize stuff. You don't need to memorize it anymore. It's all right there on your computer, right? So what we want to assess is your ability to solve problems. So open book is fine, right? You can look up the law. We want to see how you can apply the law to solve problems. So that's the assessments. Are exams a requirement in the online model? Well, yes, I've addressed that. Not all units, some units will have these take-home exams, we call them, which you do at home in, say, a 2, 4, 6 hour window where the question's released and then you submit it online. Question, are we assessing CSP based on latest degree, such as PhD or the undergraduate degree? On the latest degree, but all of it is usually in your application, at least the ones that I see, going right back to your ATAR, your HSC as well. No, I don't care about your HSC, I have to say, but it seems to be very thorough, all the things that you've ever studied. And thanks, Vivi, for answering that question in the chat. If you think of a question later, which you may well, or tomorrow or next week, you can email me anytime, right? I'm just andrew.burke. You can see my name on the screen at mq.edu.au, or you can just Google me, Andrew Burke, MQ, and my email will come up, right? Anytime. So there's a question there, can you do the whole course online? Yes, you can do the whole Juris Doctor online if you wish. Don't have to, but you can, right? Never come to campus. We have students who are in London, for example. Right? I mean, Australian citizens living in London doing a Macquarie Juris Doctor. Okay, so I'm just chatting my email. There we go. Okay, so more questions. How many subjects can be taken per term to finish in 3 years? Full-time is 4 subjects per semester, so 3 years, right? 8 subjects a year, 24 subjects in total in 3 years is full-time. Now, you might be able, we have a compressed S3, a summer semester, where you might be able to do a unit there and only 3 in but basically it's four subjects a semester. Hamish asking whether we recommend going into criminal law if we feel like we would struggle to act against our own moral views when representing clients, which is a common issue that most criminal lawyers have to learn to deal with. Look, I always recommend criminal law because I love it, and I love being a criminal lawyer, and I love teaching it. You do represent people sometimes that you don't like, and you have to be able to deal with that, and you have to be able to do your very best for people, no matter what you think of them, because that's how the system works, and that is essential to our freedom in the liberal democratic society that we are. Once somebody starts doing a poor job on purpose for somebody, even if they're a terrible person, the system falls apart. So you have to be willing to do that, and you've got to be okay with that. If you're not, then maybe it's not for you. But I always had no trouble with doing that, to be honest, because that's just the right thing to do. But that's what the system requires. So many questions. This is excellent. That's right. Everyone does have a right to a defence. Very important. Any recommendations for reading materials? You can always get in touch with me and find out in advance what your texts are going to be, and I can let you know if you want to buy them and start reading them in advance. Otherwise, just generally taking an interest. For example, if you're into criminal law, there's a great podcast called The Wigs like barristers wear, which is 3 criminal barristers in New South Wales just talking about criminal law. So there's lots of great sort of resources out there to get into it. The face-to-face classes on Saturdays? No, there's not. Only on weekdays. And suggestions on skills to acquire. Critical thinking. Critical thinking, sure. But look, we'll teach the skills. What I would suggest is that reading legal judgments and legal text takes some practice. So certainly getting a textbook is not a bad idea. Or you could even start trying to read some basic case law judgments, which you can find online. Recent cases that have been published there. And at first you might find them a bit confusing, but it's a really important skill to be able to read legal writing. Do we have to internship to complete the program? Yes, everybody has to do a PACE unit, a professional and community engagement unit. So that's an internship of sorts. It's not generally paid. Some students in their towards the end might be working as a paralegal at a law firm as well, and then they can double up, use that paid work as their PACE placement. In that case, it'd be paid for sure, but otherwise it's not generally paid. Just to be clear, I'm not quite sure what the question is asking. Once you finish the degree, you also have to do College of Law, right, which is not run by us, which is called Practical Legal Training, which requires some supervised period in the workforce for which, yes, you would be paid, and some online coursework that you do at the same time. But that's way down the track. It's common for professional things. Accounting has something similar. You have to be supervised by a more experienced lawyer in the workplace for a period of time. Okay, advantages of JD Macquarie versus University of Sydney. Look, hard for me to say because I don't know so much about the University of Sydney and how they work. I do think our flexibility is really good. I think we're really good at the online teaching as well. I think our PACE unit is great for getting students into the workforce. And I know that our Student Society provides those excellent kind of career opportunities and career fairs and all that information really super well. But yes, I'm not super familiar with Sydney's JD course, so it's hard for me to say. Any other questions? Okay, so you can see on the screen there's the QR code as well, all the information, and you can book personal consultations as well if you want to have a bit more of a discussion face-to-face too. So abundant opportunities to get more information, have all your questions answered, and we're super happy to do that. Otherwise, I think we might be coming to the end. I hope that was helpful and interesting and informative for everybody. Thanks again to Amanda for the presentation. And I hope to see some of you in class before too long.